Together with the Young ICCA Events Coordinator, Ana Coimbra Trigo, we're very pleased to welcome you to this webinar on cross-examination in international arbitration. This is the first Young ICCA webinar, which will take the form of a workshop, meaning that in the mock sessions, some of our participants will be able to practice cross-examination virtually, of course, and then they will receive feedback from our faculty. First of all, I would like to thank the steering committee members for making this webinar possible. And I'll start with Jacob Grierson, Thomas Granier, Otman Anis, and Aida Amor, who helped us throughout the process of setting this webinar up, and who are also here today to play various roles. You will be seeing them during the panel session, during the mock sessions. So we're very lucky to have them with us. And again, their support has been really tremendous. We're also very lucky to have with us a stellar faculty. And I'm not only talking about our speakers, our panelists, I'm also talking about the mock tribunal members and the mock witnesses who have made themselves available on a Saturday. So a big thanks to you all. It's great to have you here, and we look forward to the panel discussions and the mock sessions. And now, before we begin, I would like to just say a few words about Young ICCA. So for those who don't know what Young ICCA is Young ICCA is an international arbitration association for young students and young practitioners. It was established in 2010 with the mission of opening the doors of international arbitration to people worldwide. Young ICCA has four main activities. The first one is its events, like the one that we have today. And all of the events of this year, unfortunately, have become virtual, but we hope that 2021 will allow us to go back to our physical in-person workshops. And one of our flagship events is the cross-examination workshop. And again, we hope that we will be able to resume our in-person workshops next year. Second, we have a mentoring program. It's a 2-year program that connects a mentor, a very experienced practitioner, arbitration practitioner, to 3 to 4 mentees, and a buddy who is a mid-level associate. And they get together and they exchange ideas, thoughts about the practice of international arbitration. They can write publications together. They can organize events. And the next cycle of the mentoring program will start next year, 2021. And the applications for the following cycle will open in September 2021. Our third activity is our scholarships. We have currently 3 scholarships, one with the MIDS in Geneva, the second one with the Miami Law School, and third, the one with Tsinghua Law School in Beijing. And finally, we have a blog where our members can post short articles about developments in their own jurisdictions relating to arbitration. And these articles get automatically reposted on Kluwer Arbitration blog. So if you need any further information about Young ICCA, just please visit our website. It's all there, all the information is there. And of course, don't forget that joining Young ICCA is free. And this event also is free. So again, we try to give access to as many young practitioners as possible. And so with this, I'm now going to briefly discuss the logistics of today's webinar. So we will start first with the panel session. that will last around 30 to 40 minutes, and we will have 3 experienced practitioners and 1 moderator discussing the practice of cross-examination in international arbitration. They will share the tips on how to conduct cross-examination. We will also have 5 or 10 minutes to take questions from you, and you can use the chat function on Zoom to ask your questions. And then once the panel session is over, we will allocate you to 5 breakout rooms to start the mock cross-examination sessions. And I will get back to the specific logistics of this second part of the webinar when the panel session is over. I will tell you exactly who is supposed to be where, what your role is going to be. So don't worry if things are not clear right now. And then once the mock sessions are over, the cross-examination sessions, I'll ask you to come back to, we will actually bring you back to the main room just for the closing remarks. And in total, we expect the duration of the webinar to be around 1.5 hours. So without further ado, I will now give the floor to the moderator of today's panel, Ms. Susan Kimani. Ms. Susan is a co-registrar at the Mauritius International Arbitration Center. She's also a legal counsel at the PCA, the Permanent Court of Arbitration in The Hague. She's also a Young ICCA events coordinator, and she has helped us a lot with many events that we have organized so far. And she's currently doing an LLM at Harvard Law School. And she's admitted to the Kenyan bar and has previously worked in Kenya and in the Netherlands. So, Susan, the floor is yours.
Thank you very much, Panos. Hello, everyone, and thank you once again for being with us here today on a Saturday. We are joined by an eminent panel of international arbitration practitioners who will be giving us some tips on cross-examination, as Panos has noted. And we will start by hearing the panelists' interventions on different aspects of cross-examination, which include some of the questions that you as the participants have raised. Afterwards, depending on the time, the panel will take some questions from the participants. So should you have any live questions that come up during the discussion, please post them in the chat and the panel will try to get to them. I will start by introducing all the panelists, and then we'll proceed to their interventions followed by the Q&A. Now, we have with us Mr. Jacob Grayson. Jacob heads Asaf Co's international arbitration practice and is based in the firm's Paris office. His practice is focused on representing clients in relation to a wide range of arbitrations, including disputes arising out of oil and gas, mining, power, construction, telecom, and pharmaceutical industries. Jacob has represented clients in matters involving foreign investment disputes, joint venture disputes, post-merger and acquisition disputes, licensing disputes, and distribution and franchising disputes, among others. He is a graduate of Balliol College, Oxford University, and the College of Europe in Bruges, and a qualified English barrister and a French avocat. He has extensive experience in arbitrations under the ICC rules of arbitration, as well as in many other types of arbitrations, ad hoc, ICSID, HCAC, LCIA, among others. And he has acted as an arbitrator, sole president and co-arbitrator in a number of arbitrations. Finally, Jacob is a vice president of the Casablanca International Mediation and Arbitration Center, CIMAC. Jacob will talk to us today about the do's of cross-examination, and we look forward to that. Thank you for joining us today, Jacob. We also have with us Ms. Filipa Canzado Calvario. Filipa is a lawyer with more than 20 years of experience in international dispute resolution. She has worked in around 50 arbitrations in Portuguese, English, French, and Spanish in different capacities. Prior to dedicating herself exclusively to arbitration, Filipa worked as a construction infrastructure lawyer for 10 years, assisting clients in projects in different continents. At the beginning of this year, Filipa left one of Portugal's leading firms to create her own firm, FCC Arb, focused on her work as an independent arbitrator and mediator. Filipa is a mediator certified by CERD. She is a member of the Board of Arbitration Center of the Portuguese Chamber of Commerce and Industry, that is Portugal's main arbitration institution, and co-chairs the mentoring program of CEA Mehuras. She regularly participates as a lecturer in graduate and postgraduate courses on arbitration and a speaker in conferences. Filipa will be speaking to us today about the don'ts of cross-examination. Thank you for joining us today, Filipa. Lastly, but definitely not least, we have with us Mr. Jalal El-Adab. Jalal is a partner at Bird & Bird in the Dispute Resolution Group in Paris. He is the head of the arbitration department in France and a member of the dispute resolution practice in the UAE, where he offers the clients his long-standing and cross-border expertise in managing international disputes and arbitrations, especially in international business law, notably in Europe, Africa, and the MENA region, focusing on international disputes and foreign investments. Jalal acts as a counsel and arbitrator and an expert in various sectors, such as telecoms, ports, airports, construction, life, sciences, sports, and much more. Jalal is a member of the International Court of Arbitration of the ICC. He also chairs the European branch of the Chartered Institute of Arbitrators and is a senior vice chair of the IBA Arab Regional Forum. Jalal is qualified to practice in Beirut, Paris, and New York, and is equally fluent in Arabic, English, and French. Jalal will speak to us about an issue that we are all likely to be grappling with right now, and that is adapting to the virtual world. Specifically, he'll address the differences in cross-examination between virtual and physical hearings. And he'll also speak to us about the role of junior lawyers in preparing cross-examination. Thank you for joining us today, Jalal. Now, let's go back to the beginning, to you, Jacob. And please tell us, what are some of the do's of cross-examination that we should be aware of?
Susan, thank you very much. Thanks for those introductions. Just before I come to answer your question about the do's, let me first of all say it's fantastic to see so many of you making this effort on a Saturday afternoon to learn about, but more importantly, to practice cross-examination. 90 of you, or 90 of us in any case. That's absolutely astonishing. So I'm really, really, really pleased to see that. And I said learning about, but more importantly, practicing, because the cross-examination is a little bit, and I often say this, and Tomo, who's heard me, Tomo Gani, who's heard me give two of these speeches before, will probably groan. It is like learning to drive a car. There's only a certain amount you can do by listening to people like myself or Philippa or Jalal speaking to you. You've just got to get out there and do it. And it's partly because it's like driving a car, you just have to learn the reflexes, but it's also because each of us has our own style, and every cross-examiner cross-examines in a different way. There is no one way of doing it. I know that Jalal, we were speaking about this the other day. One of the points, I think, without wanting to spoil it for everyone, one of the points he wants to make is that, there are no, particularly in international arbitration, there are no rules as there might be in England or America. There are lots of different ways to do it. But even in a place where there are strict rules like England or America, everybody has their own style. And the only way you can find out your style is to get out there and practice. So having said that, I will, in spite of that, give some tips on what I think are the do's, and then Philippa's going to give tips on the don'ts. My do's come, and if I were to do the don'ts, even more so, come from very, very hard-earned experience. There were literally moments when I was out there in various magistrates' courts around England where I wished that I had a saw to cut a hole in the floor on which I was standing, so I could just drop through and disappear. There are times when cross-examination goes badly and it's hideous, but the times when it goes well are fantastic. So the right approach is that when it goes badly, just remember you're learning and you're going to get better as a result. On the whole, that hopefully is what happens. So here are I think I've got 9 tips in total, and Susan, I hope I'm not going to take up too much time. Just tell me to shut up when you want me to. The first point I'd say is, do remember what the point of each of your questions is. If you find yourself asking questions because you just think that's kind of a nice question to ask, and you don't really know what the point of it is, and believe me, that happens to all of us at some stage during our career and normally during any cross-examination. But when you're doing that, something's gone wrong. You've lost track of what the purpose of your cross-examination is. You've got to, and many people, when they write out their script, they have, underneath the heading of each section, a little bit in bold or bold italics, whatever it is, saying, this is what we're trying to get out. This is the point we're trying to make. And that, you've got to keep that, I believe, in your mind, back of your mind, or maybe in the forefront of your mind, as you're asking all the questions. Otherwise, as I said, something's gone wrong. Just maybe this is an opportunity while I'm on this first point to pick up one of the excellent questions that was sent through to us. I don't know who it was who sent it, but somebody asked, effectively, I'm paraphrasing it because I haven't got the exact wording in front of me, but effectively, what do you do when there's a really tricky question? You don't know what the answer is going to be, but it's quite an important issue. Do you just overlook it, or will you be criticized in the end for not having put the point to the other, to the witness? Well, the answer, I think, is that unless you're before a very English set of arbitrators, there's no rule that you have to put every part of your case to the witness. That is the rule in England, or at least it was when I was a proper barrister there. It's certainly not the rule in any way in any kind of international arbitration. On the other hand, if there's something really important, some allegation that you're making that somebody's misappropriated funds or something like that, and you don't put that allegation to that person, it's a little difficult then to make that allegation or to ask the tribunal to accept that allegation. So as with everything, it depends, as one would say. So great question, but I'm afraid I can't give a simple answer. My second tip is one you probably already all know, which is when you're asking questions, make sure they're closed and leading questions insofar as possible, and with a few exceptions. There are exceptions, but on the whole, all of your questions should be closed and leading. And that's really for two reasons. First of all, if you don't make it closed, then the witness can kind of grandstand and make great speeches and go on, and it's very difficult for you to stop them, particularly I think in over Zoom, over virtual platforms, very difficult to step in and interrupt. But also you lose control. You want to have control of the witness the whole time, and the way to do that is with short, simple. That's my next point. In fact, point number 3 is keep it simple for exactly the same reason. You don't want to overcomplicate it, otherwise you will lose control of your witness, and you will lose control also of the tribunal's interest in the whole process. And they'll start, particularly if it's over Zoom, they'll start looking at their emails, which are conveniently on the same screen as the Zoom page. So that was then the third point. Fourth point: do build things up piece by piece. In other words, don't rush into the best point immediately. You've got to get all the building blocks in place so you're then able to make the punchline, make the good point. It's like anything. It's like telling a story, telling a joke. You can't just rush into the punchline straight away. You've got to set it up. But on the other hand, don't make it too long either, obviously, because otherwise you'll lose the interest of the tribunal, and they'll be doing something completely different or just be asleep by the time you do come to your punchline. And this is a very important point, this is my 5th point, do remain flexible. In other words, don't be in any way a slave to your script. And above all, and this is still part of my 5th point, do listen to the answers. You can have spent so long working on your script for cross-examination, thinking, yes, I know he or she will answer this way or that way. And then suddenly you get a different answer. You get, for whatever reason it is, something goes off on a tangent. There's nothing worse than a cross-examiner who just continues as though he or she had got the answer that had been expected rather than the one that was actually given. You have to remain flexible. You can't be a slave to your script. My 6th point, very simply, do remain calm and dispassionate at all times. That's obviously, easy to remember when things are going badly. You just keep your poker face. But it's important also when things are going really well. Don't smile, grin, do high fives with your teammates, and above all, don't say thank you very much to the witness, because when things start to go less well and you're not smiling, grinning, etc., it'll be very obvious to the tribunal that things are not going the way that you want them to go. Seventhly, deal well with interruptions from the arbitrators. And I find this one of the hardest things. You're really getting into your cross-examination, and then the arbitrator says, but hold on, do we really need to know about this? It's really difficult because you're fighting the witness in a sense, and then also you have to deal with the arbitrator and explain why, in fact, it's super important that you ask these questions. I think on the whole, the best approach is just to go with what the arbitrator wants. If they feel, rightly or wrongly, that they've heard enough about a certain point, give in gracefully. It's at the end of the day, the arbitrator is the person you've got to please, and that's a good way of pleasing them, is by showing that you're receptive to what they want. I have to say, I find that always incredibly difficult because I really want to carry on with the points that I'm making. Sometimes, on the other hand, you'll be really grateful because you think, oh goodness, thank goodness that gives me an opportunity to get out of this dreadful line which was going nowhere. And then eighth point, obviously hugely important, fairly obvious, but you really do have to do it. Do prepare fully. You need to think through every question so much as to what the possible answers could be. You have to use your imagination to think how somebody who doesn't think exactly like you might answer the question. And then you have to look at the documents, and particularly in the kind of arbitrations that we're going to be doing, or the kind of cross-examinations that we as international arbitration practitioners will be doing. It's all often really about the documents. Look at them carefully. Don't overlook the bits which are not helpful to you, because those will be drawn to your attention by the witness, by the tribunal, by the other side's counsel. And you can look very silly if you just overlook that. And then my final ninth point, and I apologize if I've taken too long, I've already made this point, but I'll make it again. Do find every opportunity to practice. And so Anna and Panos and the others who have made this possible, thank you for giving people the opportunity to do cross-examination practice. And I'm going to shut up because I want to hear from others. And above all, I'm really looking forward to seeing the cross-examination practices. Thank you.
Thank you very much, Jacob. And I actually do have a follow-up question from something you said about losing control of the witness. What do you do when you start your cross-examination, it's going great, you're confident, and then all of a sudden something happens and you lose control of the witness, and the temptation is to panic, and it becomes clear to the tribunal and everybody in the room that you're panicking. What do you do then?
That's a great question. What do you do when you're panicking? Take a deep breath. That's I think the only way to get over panic. People forget very quickly a lot of things, including the fact that your first few questions may not have gone so well. It's like with anything in life, you can pick up very quickly. So I think it's a bit of deep breathing, a bit of positive thinking can get you over that. And then the other thing, the other practical thing is switch to another topic. I mean, if things are going badly on one topic, obviously don't. But I think this may be one of the don'ts that Philippa will be mentioning. Don't dig further. Know when to stop digging. Move on to another topic. Make it look as if actually that was all you wanted to ask anyway. Don't shake your head and say, oh, okay, all right, well, let's move on, or well, maybe we'll come back to that later on. Just move on neatly to another topic. Deep breathing, positive thinking, and it should be fun.
Right. Thank you very much. That's very insightful. Now, Philippa, we want to hear from you about the don'ts, and I'm actually quite interested to hear your view about this issue of what happens when you're losing control. What should you not do, actually, when you feel like you're losing control of the witness and you're losing the interest of the tribunal? You're just basically losing the trail of the cross-examination. So welcome, Philippa. Yeah.
Thank you, Susan. Well, Jacob, you have so eloquently thanked the organizers and the people that are here watching with us. I cannot do a better job, so I will just adhere to what you've said and move on to the don'ts. And I will start first, before addressing my don'ts, I will start with the point that you were asking, Susan. I think there's one thing that we all need to remember. Someone taught me this a long time ago, which is when you're panicking, the other people do not necessarily see that you're panicking. So when you feel that you're trembling inside, that your heart is bumping, is in your brain, other people are not necessarily seeing that. So I think Jacob's advice, you can have a set of pre-prepared sentences for panic moments. So let's come back to that in a while. But now I want to ask you something. So you must have a set of topics, safe topics, so to say, where you can go to have an escape route if things are going wrong. So, and even those moments of silence that you think everybody's staring at me and everybody knows that I don't know what I'm doing. People don't understand silence the same way as you. So be reassured that people are not seeing what you are feeling, and regain your trust and move on, as Jacob said, to another topic. So that's a good point. Starting with the don'ts, so I'm going to pick up some advice that is usually given to cross-examiners, not exhaustively because we don't have a time, but elaborate a little bit on each of those points. So my first point, my first don't in cross-examination is don't do it. And don't do it, I'm talking about cross-examination, which seems a bit of a paradox, but this is just an exaggeration to catch your attention and to make you think that you don't necessarily have to cross-examine every single witness that there is. So you should think carefully about whether you need or not to cross-examine each witness, and you should only do it if you have a clear and attainable purpose with that cross-examination. So in deciding this, you should always remember that even the best cross-examiner in the world cannot control, redirect, and the questions that the tribunal will ask. This is an important point. And that you usually in arbitration, if you don't call a witness, a little bit like Jacob was saying, that does not mean that you accept their witness statement as being true. And when you call someone, you are probably making the difference between the tribunal knowing or not knowing that person. So you're essentially transforming words into a person. And there is a risk that by seeing that person will be more persuasive for the tribunal and you will be giving him or her more importance. So you have to think about this. And what you can do is know very well your case theory and then see what topics you need so that your case theory prevails, and look, as Jacob was saying, to the documents and to the witnesses, what they say and what they don't say, to see what points you can realistically try to achieve with which witness. And so this is how you can try to identify which witnesses you can call or not call. So another don't is don't ask questions to which you don't know the answer. And the point here is that you should be aware that it's very risky to venture and ask questions to the witness when you have no idea what the answer will be. And of course, witnesses are a little bit like children, so they say the most surprising and extraordinary things. You don't know what they're going to say. But you can, if you know the case very well, if you know your documents and know the evidence, you can guess what they will say most times, and you can know what is the right answer to your questions. And you can be prepared if the witness strays from the righteous path, which is the question, the answers that you want them to give. You can be prepared with documents that refute the answer that the witness is saying, but with documents and lines of questioning. Of course, this is easier said than done and requires some practice, but in most cases, there's a lot on the record, and in international arbitration especially, there's so many things that even a witness that has prepared themselves for cross-examination will a lot of times not know the file as good as you. So you have a lot of chances there to extract good facts for your post-hearing submissions. So another don't ask the one question too many. And there's a lot of debate about this, so we can define the one question too many as a question that needed not be asked. And when the witness is answering it, you are giving the witness an opportunity to destroy or diminish your accomplishment so far in that cross-examination. So every single question that you ask once you have attained your goal in that point is a one question too many. Of course, there is a slightly different thing, which is when the one question too many is a question that is the obvious follow-up of your line of questions, that is so obvious that in redirect or the tribunal may put that question to the witness. Perhaps that's not a point of one question too many, or it means that every single question on that line of questions is a one question too many, because you should not choose points that are so weak that a single question in redirect or by the tribunal can destroy the point that you're trying to make. So a good example for me of a one question too many is when you have established or confirmed the facts that you wanted with the witness, and you then try to have the witness agree with you, the conclusion or the inference that you want to extract from those facts. Those things are best left for post-hearing submissions, because otherwise you will enter into an argument, lose control, as Jacob was saying, and you risk destroying what you have accomplished so far. Also, a good example of one question too many are questions that ask why to the witness, or ask the witness to explain, or invite them to make a speech, unless, of course, and this is also a point about my previous point about don't making a question where you don't know the answer, unless you either know the answer or you don't care about what the answer is. So if the question, and this is not, I think, a proper question in cross-examination, but it is, were you lying or you were corrupted? You don't care about what the answer is to either of these questions, because they both serve your purpose. But unless you are really, really sure that you don't care about the questions, why is a very dangerous question. Another point, another don't, and I want to emphasize that these, if you have watched Pirates of the Caribbean, these are being prefaced as rules, but these are really more like guidelines. So there has to be flexibility, as Jacob was saying, and you shouldn't take this at face value. You should find your style, absolutely. And don't assume that if you're not from a common law jurisdiction, you're going to be worse at this than people from common law jurisdictions, because that is not at all my view. So this is a sideline. So don't be aggressive, don't argue with the witness. So here, you are the professional. You do this for a living. Even if you're only doing it for the first time, you have you want to do this for a living. And the witness is usually not a professional witness. So you are in this balance of forces, you're the powerful one. If you start to discuss with the witness, you risk suggesting to the tribunal that the witness is damaging your case. You are losing credibility before the tribunal. You risk becoming less persuasive, and you risk also creating sympathy for the witness. So you should not do this. Again, this is easier said than done. And it's a little bit difficult sometimes. You have prepared your cross-examination, you're putting the questions to the witness is not answering. So you have to be prepared for these things in advance. And one thing that, in my view, there are instances where you can discuss with the witness, or not discuss, I'm sorry, you can get angry with the witness, but only if it's really obvious for everyone in the room, not only for you, that the witness really had it coming. Usually, it's much better to be nice, polite, cordial with the witness. The witness does not answer your question. You say, oh, I'm sorry, maybe I did not, I was not clear in my question. What I was asking was, and you put the question again, and the witness again is evasive. And you reformulate and ask the question again. And even if the witness is not answering your question, at a certain point, you have perhaps attained something which is even better than the answer you were looking for, which is that this witness does not want to answer your questions. And again, there is a number of set phrases that you can collect. I used to do this in the beginning of my career. When I listened to a very good phrase in cross-examination, I had a list. And so if the witness is making speeches, for instance, you can allow the witness to make a speech for the first time. Because if you interrupt them, it seems like you want to hide something from the tribunal. And so allow them, and then you can say, well, actually, thank you very much, but that was not my question. My question was this. And if the witness continues at a certain moment, and you have to choose the moment very well, you can be a bit more aggressive or passive aggressive and say something like, well, I understand that you want to make these speeches because you think this is helpful for your case, but actually this was not my question, and we're on a tight schedule, and I have questions to ask you. So I would ask you, can you please listen to my question and answer my question, perhaps in a little even less aggressive tone that I've used now. And that will usually put the tribunal on your side, and you're emphasizing that the witness is not collaborating but not losing composure, and it will help the tribunal be on your side and not on the witness's side. So I think that I may be more or less in my time, Susan, or do I still have time for 1 or 2 points?
You may proceed and give 1 or 2 points.
Okay, so two. I will try to be brief. 2 points. Don't misuse documents. Documents are very helpful to assist you in controlling the witness. But one thing that I've seen, which I think is not effective at all, is either asking questions to the witnesses about documents that they don't know of and that they should not know of, or asking witnesses to read documents to validate the contents of documents. And sometimes it may be that you want to draw the tribunal's attentions for these documents, but perhaps it's more effective to do that in initial pleadings, for instance. And another thing, and I've actually seen this happening, is when you have a document which content is clear, and you ask the witness to confirm something which was already clear, and the witness destroys what the document said and gives a different interpretation, and suddenly you had a perfectly good document which content is not now as clear as it was before. So this, in my mind, is not a very good use of documents. And the other thing, Jacob, is preparation is key in cross-examination. It's a little bit, I'm sorry, I have kids, so I have these references that I don't know if you've watched Ratatouille, and there is this chef, and he says, everyone can cook, and everyone can cross-examine. You have to have a little bit, you have to have common sense, be intelligent, which I'm sure you all are, so every one of you can cross-examine. And you don't need to be a brilliant cross-examiner from the get-go, because what makes a good cross-examiner is 90% preparation. Perhaps now in virtual hearings, 95%. So everyone can do this. And in your preparation, you should not only prepare the cross-examination, but have an escape route, as I was saying, for when things go wrong. And you should very carefully prepare beginnings and endings. Beginnings because first impressions are important, not only for the tribunal, but for the witness. So if you want to control the witness, one of the big parts of that is for the witness to understand that you are controlling them and that resistance is futile. And you can do that by starting strong in your cross-examination. And you should always finish strong. There's research that shows that people remember more the beginning and the end than everything that is in the middle. And if you finish on a weak point, you risk leaving an impression to the arbitrators that, after all, your cross-examination was not so good. Conversely, if you finish on a high note, they will feel that you actually did a very good cross-examination, even if the middle was only so-so. So this is, I will end on end notes. That's all for now. Thank you, Susan.
Thank you, Philippa, and for ending on a high note. That's very, very valuable points that you've actually answered some of the follow-up questions that I had in my mind as you spoke. So thank you very much. And we'll come back later with some more questions. Now let's proceed to Jalal. Jalal, what are some of the differences in techniques, cross-examination techniques, between a virtual hearing and a physical hearing, and how do you adapt your case to suit the different platforms? And as you address that, please also talk to us on the role of junior lawyers in preparing for cross-examination, given that most of us here are young or junior lawyers. Welcome, Jalal.
Thank you, Susan. I can't say how much I'm happy to be amongst you, even if it's virtually. It's very nice to be speaking and involved in a webinar on a Saturday. Some of you went not mute, but without a video, but I have seen some. Well, I think Loreen has the background of a beach behind her, which really looks great. It feels like going wherever she is. I have seen the picture of someone else actually like chilling around, perhaps sitting on a bed. That's exactly the mood in which I am today. So if I'm not as rigorous as Philippa and Jacob have been, excuse me in advance, and excuse my French. So let me start by thanking once again Young ICCA. It's an amazing forum. I was invited a few years ago at the PCA to talk about my experience with the Arab countries, and it was really a fun, very interactive session, and it seems it continues to be so. I'm really glad again to be here, and I'd like to start with the end, since Philippa said it's important to make sure you start well and you finish well, by answering Susan's second question, which are basically which is a good transition, I think, with what was said. And I'd like to make that point, i.e. Those tips for all of you who are, so to speak, junior, and would like to have some very practical tips. And I'd like to share with you not some tips, because I don't. It would be pretentious to tell you this is what should be done and should not be done, which is not exactly what Philippa and Jacob has done, because really it's about advice. And then I'll be moving to those virtual or remote tips. The first thing that I'd like to add to what was just said is really a fundamental point, and that applies to a virtual setting, which is relax. Relax, especially for those of you who are not from a common law background, who may have a sort of, as we say in French, a complex, because basically they would supposedly not be familiar with what they see or would have seen on TV, in a TV show like Shoots or anything like that. That's really not what is at stake. And precisely, I think fundamentally one may have to ask him or herself, what is the exercise of cross-examination about? Is it about the truth? It is very rare that you get a smoking gun, exactly like from a discovery process, so-called discovery. You get this sort of document that would be adverse to the interest of the party that has produced it. Is it about more credibility? Probably, and you have different techniques to test that credibility. And this is why it is important to know about cross-examination, at least theoretically, and then being relaxed about how it's applied in arbitration. I'm just laying these foundational ideas because sometimes I think we overestimate what we as lawyers often do in an arbitration, or often think we do in an arbitration. I think it's important to have advocacy skills, but let's not think that we are the sort of the sort of player who's going to make the whole game actually switch to a winning case, from a losing case to a winning case. And this is all the more true that many times people, and I have been asked about that, would really try to theorize, for example, what is a leading question and what is allowed in terms of asking leading questions or not. And if you get to see what are the applicable rules, and those are not even mandatory rules, this is soft law, and I mean by this the IBA rules. Well, those of you who would go and look at what is, let's say, permissible or accepted, there is nothing about forbidding leading questions. What is said, I think it's at Article 8.2, that the question may not be unreasonably leading. And here you see my whole point is that don't focus too much on those techniques of what is impeaching a witness or an expert, about those fundamental rules that you would see in a very specific setting. Those are for a judiciary system, not international arbitration. So again, be flexible, be relaxed about that. And I remember, and I'll be finished before moving to the actual first set of tips, which are the virtual tips. The whole thing about, direct, cross, and then redirect is something also perhaps a little bit too theorized, even in procedure orders number 1. Why? Because simply you have, sometimes very detailed text about what is allowed in redirect, what is not. And then I remember even with French lawyers discussing about what was the scope of the redirect. And then, of course, I simply basically discussed with that person who was not a New York lawyer, whether he knew exactly what was the theory of opening the door to a set of new queries. And it went simply nowhere, simply because, again, there's not a fundamental rule about those techniques. I think it's really about making sure that you test the credibility of a witness substantially, and in terms, of course, of credibility, I mean, whether he is competent, and if it's an expert, he's competent in his technical field to testify. Now, moving to those very practical tips. I have been involved, like many of you, in virtual hearings for the past few months. And what I would suggest you do is really get into techniques, and by techniques I mean IT techniques, beneath a virtual hearing. Know more about what is Zoom, how Zoom functions, etc. And then you will understand that there are fundamentals that you need to know. And very simply, one way to do that is to start by preparing the actual virtual hearing with the IT people. And if you do so, you really get to know what are the fundamentals of a good virtual hearing. And of course, in that, a good virtual cross-examination. And of course, that means that you get to know how important is the bandwidth. And when you prepare your witness, there are tips that you need to convey to him or her. One of them, which is basic, and you all know about it, is that when he's going to connect, well, make sure his he is likely to be at home, that the kids are not basically streaming videos or are not simply playing games, that is simply eating the entirety of the bandwidth and not leaving much space for the witness to be heard or seen. That's stupid, but that's really those technical fundamentals you want to test with your IT people. But by the same token, there are fundamentals that you are to know. Simply the appearance, and I'll move to the question of the voice. Susan, how much time do I still have before I'm done?
You have about 2 minutes to go, Jalal.
Okay, I'll be quick, I promise. I think that the setting is very important. Of course, if you look at the background of someone like Jacob, who has a very nice billboard with Asafo behind him, I think that's exactly what a witness should not be doing. I think the more he shows that this is a setting where he's speaking from, which is very casual, normal, not too much prepared. And I have seen, believe me, some very fancy backgrounds which looked very awkward. And of course, we did not expect this from the witness. He wanted basically to convey a very impressive message that he was prepared, etc. But the overall background was not that good. The voice is very, very important. So that means that if you need to invest in a very good microphone, do this. It's not that expensive, but that means that the witness himself should certainly not connecting from an iPhone. And if he does, you should test this upstream and make sure that he doesn't move with this with his iPhone. Checking the room where he's testifying or she is testifying from, even without the tribunal asking him or her to do so. I think it's a good way to show that the only thing he has on his table is his statement, and there is no one else in the place. Perhaps one last couple of advice is that the more you repeat the virtual testimony, and you do not do it basically physically, and the more you're going to be prepared. That means that, and I have done both, and actually the best way to prepare for a cross-examination virtually is to do it virtually, i.e. the preparation. So with that, I'm sure there are many other things, like how the witness should be dressed so that basically there are no issues of color on the screen, and probably other tips that I'm overlooking, but I'm happy to answer any further questions you may have, including you, Susan. Thank you for your attention.
Thank you very much, Jalal. We have a few minutes to go, exactly 3 minutes now before we end this panel discussion. And so I'll just raise 1 or 2 questions that have come from our registrants. One of the participants in the meeting has asked whether, do you think leading questions which help the counsel steer the testimony in a way that would be favorable to the client are considered permissible in an arbitral tribunal that consists of arbitrators from common law background? Any panelist is free to take this one.
I think Jacob wants to answer, but I'll be happy to follow up on his answer.
Okay, and Jill, you've already answered by saying that for you, leading questions and all those sort of rules don't matter. Let me just make absolutely clear, because there may have been some misunderstanding, and maybe some misunderstanding as a result of what I said. The rule against leading questions in the common law systems doesn't apply to cross-examination. Quite the opposite. I hope I said before, in cross-examination, you should be asking leading questions. On the whole, not always, but on the whole, they should be leading questions. The the rule applies for direct examination or examination in chief, and for redirect, where I have to say I slightly disagree with Gio, because I think the rule is not just a sort of archaic rule for old reasons. It's actually for a good reason, because if you want the tribunal to believe that to believe what the witness is saying, it's better that it comes from them rather than from you. So if you're putting ideas, very obviously putting ideas into the tribunal's mind, into the witness's mind, the tribunal is going to realize that. And so much better to have done what most of us do, which is to put the ideas into their mind before they give evidence, have a little rehearsal before. Obviously, in some countries you're not allowed to do that, but in most you are. Have a little rehearsal, and then you ask the open question, to which doesn't suggest the answer, and the witness gives the answer. I think that's just much more effective like that. But again, it's nothing to do with cross-examination.
Did you have something to add?
Yes. Well, as always, or very often, I concur with what Jacob just said. The point I was trying to make, and to answer the question by Naime, I hope I'm pronouncing correctly his or her name. I think it's really that. Well, I quoted Article 8.2 of the IBA rules. This is not the Bible again. The IBA rules, it's a compromise between common law and civil law systems. But the best way to exemplify this compromise is precisely that Article 8.2. It doesn't say leading questions are not allowed. And Jacob was just saying, well, the point is of a cross-examination and beyond cross-examination is to ask leading questions. And it is said what is not, should be avoided are unreasonably leading questions. I mean, if you're basically trying to plead your case through the mouth of the witness, this is where basically the whole exercise becomes pointless. So again, I think that leading questions are permissible and should be allowed. And again, in terms of admissibility of evidence, as you all know, tribunals are much relaxed on that, subject, of course, to mandatory rules and attorney-client privilege, for example.
Thank you very much. And before we finish, because we're now at the top of the hour and actually passed by a minute, Philippa, do you have any last words?
No, I can just add regarding the leading questions or otherwise that I'm from a civil law jurisdiction, but where we actually cross-examine witnesses, but without prior discovery or witness statements. So witnesses are heard on direct at the trial. We have no idea what they're going to say, and then on the spot, we cross-examine them. And we also have, although it's not a rule in a code, but judges will tell you that if you're questioning your own witness, you cannot put leading questions to them, because if you're putting leading questions to your witness, she's going to think this is the lawyer of the party for whom I'm here for, so I should agree with him. But that risk does not exist when you're cross-examining an adverse witness, which has no reason to help you advance your case. And so in that case, there is no risk coming for the search of truth or whatever it is that that cross-examination serves for, because the witness has no bias to agree with you. So in that sense, the situation is very different in one scenario and the other. So that's it.
Well, thank you very much, Philippa, and to all the panelists. I believe we are now sufficiently armed to go into cross-examination. So we look forward to the next part of this. Yeah, over to you, Panos.
Thank you very much, Susan, and thank you again to all of our panelists for their excellent tips on cross-examination. We will now move to the second part of the webinar, which is, I think, the fun part. That's why most of you are here today. So we will open 5 breakout rooms, and there will be 1 arbitrator per room and 2 witnesses per room. So 1 for claimant and 1 for respondent. And we will have 10 teams, in total 10 cross-examination teams. Again, 5 for claimant and 5 for respondent. And Anna will be allocating you to the breakout rooms. And then obviously, claimant's counsel will go first, cross-examining respondent's witness, and then respondent's counsel will cross-examine claimant's witness. And then, as I said at the beginning, you will have a feedback session. Both the tribunal member and the witnesses will be providing you feedback and giving you tips on what was done correctly or what can be improved. So before we open the breakout rooms, I want to briefly introduce the faculty members that haven't been introduced so far. So I will start with Thomas Granier. Thomas is counsel at Asafo & Co., as you can see from his very fancy background, Zoom background. He helped us a lot with the mock case, and the same applies with Otman Anis, who is a junior associate at Asafo & Co. in Casablanca, and Aida Amor, who is a PhD candidate in Paris. And the 3 of them helped us a lot provide some African context to the mock case, and I hope that most of you will appreciate that during your cross-examinations. We also have, as a tribunal member, we have Matthew Brown, who's an associate at Hutov in New York. We have as a witness Sofia El Baghdadi from Casablanca. We have Munia El Harti Alonso, who is now based in Washington, D.C. We have Radu Gyosen, an associate at Queen Emmanuel in Paris. We also have Amir Mardavi, an associate at Curtis Mallet and Prevost in London. Leila Orak Selikboya, associate at Altay Law Office in Istanbul. She will also be playing the role of the witness. Jody Reinford, an associate at Hogan Lovells in Dubai. And last but not least, Nadia Smahi, an associate at Bar & Carrere in Geneva. So Anna, when you're ready, please start allocating the people to the breakout rooms, and best of luck to all the cross-examiners.
Of course. Thank you. I'm Pushkar. I'm an advocate based in India. I'm a graduate of the 2020 batch, quite unfortunate to speak so. My question is regarding the cultural difference between the civil law and the common law, which generally people want to generalize it. So I just wanted to know, because if this was a case of, a bit of emotional touch where you had the CEO also coming in, bursting out the emotion, both of them just left. So, going by civil tribunals, civil law based tribunals, would they be, quite to the point, or would there be some sort of generalization that could be made? Because in common law, we go by story, we go by narration, we go by emotion. I'm not sure if that is the same in civil law countries as well.
Who wants to answer?
Panagiotis, I think we're all back.
Yes.
Yeah, there was an interesting question, Jill. You may, or maybe anyway, a civil law. Maybe Thomas has a view, or Panos, or whoever. Question is, when witnesses are emotional, does that go down better with a common law or a civil law tribunal? I probably oversimplified the question, but I think that was the question from Pushkar Keshav Murti. Don't know if anybody has a. Thomas, are you?
Yeah, no, I think you can't really. I don't think you can really distinguish between civil law and common lawyers, common law arbitrators when it comes to emotion, because what I've seen is that even in cases where there is a personal touch, arbitrators, regardless of whether they are of common law or civil law, they are human. So of course they are human beings. So of course they're going to take that into account. But above all, they're here to judge facts. They're here to assess credibility of facts, etc. So I would never try to prompt my arbitrators to cry in any event, because you can be a good storyteller, but without relying too much on emotion. Having said that, there were two components in your question. There were the emotion, and there was the storytelling. And I think here again, both civil lawyers and common lawyers, when they are arbitrators, obviously a good advocate is the one that is able to put forward a good story that is backed up by facts. So I think it's the same logic before both types of arbitrators. That would be my answer, and I would be happy for anyone to disagree, of course.
Well, after Thomas's answer, and since we are already a little bit out of schedule, I take it upon me to conclude the webinar. And so first and foremost, on behalf of Young ICCA and the steering committee, we are very happy that you are here with us today. So we'd like to thank everyone that participated both as speakers in the panel, but also as arbitrators, as witnesses, and as cross-examiners in the practical sessions. So thank you for devoting some of your time for this purpose. This is really what at Young ICCA we strive to do, meaning providing some skills building opportunities for young practitioners. So we hope that this was useful to everyone. And it's always a risk to try and replicate these kinds of events, but this is just a proof that this works. And so we'll look forward to, at Young ICCA, to putting on a couple of more of those in the future. Please note that the first part of the panel, of the webinar, the panel was recorded, so we will shortly make it available on the website as well. And last but not least, we wish everyone happy holidays and see you all in 2021. Thank you so much.